Hi, okay, here's my for Georgia contracts and torts. Sometimes in July 23 and February 23, they did it as a crossover. So but they did it separately, right? In July 22. So let's just say they'll do it separately. But if they do combine it, then Conlaw next. Does that make sense? And then Civpro, for sure. They haven't tested that for a while. That one for sure, too. And then the next one, Wills, right? Because they tested these four. So Wills, and then the wild cards will be Conlaw, family law, crimes, and then remedies. And I notice since going back 12 years, if it's remedies, it's injunctions for whatever reason. Those two happen to be injunctions. Okay, those are my Georgia predictions. So let's get into more specifics about the Georgia predictions. So if we go here, contracts. They didn't do contracts or torts last time. Amazing. Okay, so if they do it again, they may cross it over. And if they do cross it over, Conlaw becomes the fourth subject, okay? But let's just see, in terms of contracts, let's see what they did last time in 723. Okay, so breach of contract. So it looks like fraud for the tort stuff and contractual relations. Was it common law or was it? Looks like it was common law. So that makes UCC more likely. The one before that, yeah, this was a record label one. So this one was common law too. So UCC is really likely. Vicarious liability. So it's a negligence and contracts. So let's go back again. Here's a tortious interference again. They really like that one. Let's see here. Liquidated damages. I would look for a UCC. I mean, it seems like they haven't tested in a long time. Torts. I don't know. I feel like I haven't seen a negligence for a while. Since 21, negligence. Let's see if they did it. Oh, there was a negligence with the record label. Yeah, okay. Survival, statute, defamation. So maybe defamation again, okay? Watch out for that. So we have Civpro, impleader, long arm statutes, statute of limitations, choice of law, venue. It's kind of a nice variety of subjects here. Hard to lock down. MSJ. So maybe MSJ and that kind of stuff. Service of process and PJ. Okay, that's what I'm gonna call. Service of process, PJ, SMJ. Okay, wills. Wills is wills. I mean, will formalities. Sometimes they have undue influence. An older person, right? So I'm not gonna talk too much on wills because I feel like it's a very narrow subject, in my opinion. Sometimes in testate succession, but you could take a look at what they've tested before, and if you see something that they haven't tested in a while, kind of focus on that. Okay. Conlaw, since it very well could be like, I'd say it's like that. Like it's really up there. Conlaw and FamLaw. So let's talk about Conlaw, see what they've done lately. Speech, religion, speech, religion. Speech, religion, so First Amendment stuff. More First Amendment stuff. Catholic school, religion again. Free exercise clause. Okay. Speech, religion. So have they ever tested like commerce clause? No, they haven't tested it going back to 2012. So, speech, religion, more religion. Speech, religion, religion, religion. So, speech and religion. I just feel like I've seen a lot of religion, but speech was the most recent. So I'm just going to say speech or religion, okay? And again, family law is a pretty narrow subject, I think. Crimes, see what they've done just out of curiosity. So it looks like the last time they tested was 722. Unilateral conspiracy, murder, red line, Miranda, so crim pro, burglary, murder. So if we follow that pattern, could be crim pro this time, burglary and assault. So I'd say it'd be another crim pro, Miranda, over crim law. And then remedies, injunctive relief. I remember I kept on seeing property remedies here. It's like ejectment, I think, and stuff like that. Let's see what property remedies was about. Rescission, fraud, injunctive relief again. So I would just say injunctions. Okay, so that's all I have. Good luck. Please let me know in the comments if you want to say anything. No problem. Good luck. Reach out if you want to.
All right, let's do it.
Okay, let's do it. So they have 4 45-minute essays, and the first subject I'm predicting is contract, UCC, and then torts, defamation, and they could cross it over. And if they do, it brings Conlaw up higher. It brings the wild cards in more. We'll take it one at a time. So for contracts, I'm thinking UCC because it was common law last time. Have any thoughts on that or anything come to mind for you?
Yeah, I think the basic thing with UCC is you want to right from the onset, you want to say that the special rules apply. You want to think the merchant rules. And then you want to think battle of the forms. And also, if there's a delivery, you want to think of the remedies, under the merchant remedies, and what they can do if goods come in and who can reject what, and the buyer, how long they can retain the goods, if they can retain them. And then you want to just think the remedies for each buyer and each seller. Also, you want to understand the difference between consequential damages versus incidental in some of the defenses and equity, such as latches, unclean hands. Then don't forget about if there's a unforeseen circumstance, you want to think of impossibility, frustration of purpose, and impracticability. Those are all defenses that you always want to keep in mind when you're dealing with the UCC.
Yes. And then there's another one with UCC. We have cover as well, getting an alternative because of the breaching party. The remedy would be the difference you paid, right? Which they call cover.
Right. And then you want to always consider anticipatory repudiation. That comes up a lot and it's often tested a lot in a lot of bar exams, including Georgia. So you always want to know the elements and recognize it when it comes up. That'll set you apart from the other examinees on this exam.
Yeah, I forgot that you sat for Georgia already, right? So it's almost all UBE except for the essays. So it's MPT, the MB, the multiple choice, and instead of the 6, it's the...
Just remembered, you also want to remember the perfect tender rule out of the UCC. And if the goods fail in any aspect, then they can be rejected. And the person receiving the shipment, the buyer, typically can reject the entire shipment. They can accept it, they can accept some, and then reject some. So understanding the duties and the rights of a buyer under the perfect tender rule under the UCC, I think, is also important.
Yes. So next, we have torts, and I haven't seen defamation for a while. So
with defamation, there's a lot of areas in defamation and the privacy torts that you can go. So you want to understand the difference between defamation and then constitutional defamation. The elements of the defamation, defamatory statement concerning the plaintiff and the publication, and then also don't forget damages, and then understanding also the constitutional considerations, which are 2 separate elements. That would be the state of mind and falsity, and discussing that. And then also you want to remember that in what context is the statement taken, and that truth is always the best defense, and whether they're a statement of opinion to where it is in fact something that could be taken as a defamatory statement. And then also it's important to understand that even though something might fall under the tort of defamation, it's understanding the privacy torts, intrusion upon seclusion, and then it's putting the person in a false light, because a lot of times you might have a statement that is actually the truth, right? And it doesn't fall under the elements of being defamatory, but it's putting them into a false light. So a lot of times, if you have time, you can still discuss that, yes, well, this isn't defamatory, but you're saying a true statement, and it could be a public disclosure of a private fact, or putting the plaintiff in a false light, which would still entitle the plaintiff to damages.
So Civ Pro is next, and I have service of process, personal jurisdiction, subject matter jurisdiction.
Yeah, so these are big areas to be tested in. And personal jurisdiction, you want to tighten up your ruling on the international shoe and the elements of minimum contacts, long arm statute, but have enough time to discuss subject matter jurisdiction. And typically you're not going to have one that falls under a federal statute. A lot of times they'll want you to discuss residence and those elements of diversity, and whether there's a good faith basis of the $75,000 or more to get it into federal court. And remember, it's a good faith estimate, so sometimes you can actually have less than 75,000. But as long as there's a good faith effort, so if the case ends up being 65,000, but you pled in good faith, that would still qualify under the $75,000 threshold. Also, remember that you could have money damages of suing somebody for $60,000, right? But then you can aggregate your claims in equity, and that would be based on how much the lawsuit or the claim in equity would be valued at. So if you have an injunction that's also incorporated into the lawsuit that's valued at $15,000, you could take the $60,000 and the 15, incorporate it, and there you have your subject matter jurisdiction. And remember that it's one plaintiff, so two plaintiffs, unless there's some sort of connection of the same transaction or occurrence. But remember, typically it's one plaintiff versus one defendant, and so you wouldn't aggregate claims with two different plaintiffs against a defendant to get into federal court under subject matter jurisdiction. Then also you want to remember the ways in which a party can remove. Remember, typically a defendant is the only one that could remove, and then what are the tests to remand it back to court. So those are frequently tested and very important in civil procedure.
Yes. Wills again?
Yeah, I think with wills, it's understanding, does this person want to have capacity to enter into the will? Are they aware? And the will written, and we have the formation of the will, and then how a divorce or how a child passing away or even our beneficiary in the will, how that is going to alter the will going forward. Also looking at how an advancement affects the will, and or you want to look at whether there is an item that is no longer there, if the certain property contained in the will has a deemed, and what that does to the rest of the beneficiaries under the will. And you always want to remember and discuss what is the present intent of the testator. So there might be an issue with formation, but then use the facts to your benefit as to whether there was present intent, and always refer back to the intent of the testator and learn how to just argue those facts.
Conlaw, speech, and religion I haven't seen in a long time.
Yeah, I don't know if freedom of religion is going to come up because I think the law recently changed the limit test. So I don't know if religion is going to come up anytime soon, but I could definitely see speech, First Amendment, and understanding the doctrine of vague statutes and understanding the different types of speech, hate speech, and the different tests that are associated with speech. And then also, I know, George, they always try to test standing. So one thing in Conlaw you can always talk about from the onset to pick up more points is just state the element of standing and beware of third-party standing and know those elements.
Yes. Okay. Good. I guess that's it. I really want to thank you so much, Walt, for your time. And
you guys feel free to leave a comment, and we'll try to reach out and answer any questions you can, or if there's a topic that you may want some clarification on, we'd be willing to help.
Yeah. Thanks so much, Walt. Thank you.
Thanks.
Okay.